Imagine receiving a phone call informing you that a distant acquaintance, someone you barely considered a friend, has left you their entire $3 million estate. This isn't a movie plot. It's exactly what happened to a woman named Jenny after a wealthy, elderly gentleman, Mr. Smith, passed away in California. Jenny, a former caregiver who had provided some services to Mr. Smith years prior, was stunned. The will explicitly named her as the sole beneficiary, completely disinheriting Mr. Smith's biological nieces and nephews, who were expecting a substantial inheritance themselves. This immediate news set off a legal shockwave, as the family quickly geared up to challenge what they saw as an outrageous and unjust will. The stakes were incredibly high, with millions of dollars in family legacies hanging in the balance, creating a courtroom drama few could have predicted. But what legal grounds did the family actually have to contest a clear, written will? The Smith family, a collection of nieces and nephews, had always assumed they would inherit their uncle's considerable wealth. They had maintained a relationship with him, albeit a sometimes distant one, and saw themselves as his natural heirs. When they discovered that Jenny, a virtual stranger, was to receive everything, they were furious. They alleged that Jenny must have exerted undue influence over Mr. Smith, exploiting his age and frailty to manipulate him into changing his will. Undue influence is a powerful legal claim, suggesting that the testator, the person making the will, did not act of their own free will but was coerced or manipulated by another party. This is a common tactic in inheritance disputes, but it requires substantial evidence, not just suspicion. The family also hinted at potential mental incapacity, claiming Mr. Smith might not have been of sound mind when he signed the new will. But proving this is an incredibly high bar in U.S. courts. To prove undue influence in California, the family had to demonstrate several key elements. First, that Mr. Smith was vulnerable to influence, perhaps due to age, illness, or isolation. Second, that Jenny had the opportunity to influence him. Third, that Jenny actively participated in the drafting or execution of the will. And finally, that the will's terms were unnatural or favored Jenny over his natural heirs. This is where the family's case started to build. They pointed to the fact that Jenny was present during some discussions about Mr. Smith's estate and that the will was drafted relatively close to his passing, a period when he was in declining health. However, merely being present isn't enough. The law requires proof of actual coercion, a direct subversion of the testator's intent. The court would need to see evidence that Jenny didn't just suggest, but actually forced or manipulated Mr. Smith's decision-making process. But how do you prove something as abstract as manipulation? Another avenue for the family was to challenge Mr. Smith's mental capacity. For a will to be valid, the testator must have been of sound mind at the time they signed it. This doesn't mean perfect mental health, but rather an understanding of what a will is, the nature and extent of their property, and who their natural beneficiaries are. In legal terms, this is often called having a testamentary capacity. The family brought in medical records and testimonies suggesting Mr. Smith suffered from some cognitive decline in his later years. However, a common mistake here is assuming that any cognitive impairment automatically invalidates a will. Many people with early-stage dementia or other conditions still have lucid moments where they can make sound decisions. The court's focus would be specifically on Mr. Smith's mental state at the exact moment he executed the will. Proving he lacked capacity at that precise point requires compelling medical evidence, often from the attending physician or a specialist. What evidence did Jenny present to counter these claims? Jenny's defense centered on demonstrating that Mr. Smith was a strong-willed, independent individual who made his own decisions. Her legal team presented witnesses, including the attorney who drafted the will and the notary public, who testified that Mr. Smith appeared perfectly lucid and firm in his intentions when he signed the document. They emphasized that Mr. Smith had expressed dissatisfaction with his family's level of care and attention in his final years, often feeling neglected. Jenny's lawyers argued that the inheritance was not the result of manipulation, but a genuine expression of gratitude for the kindness and companionship she had provided, however brief. They also highlighted the fact that Mr. Smith had revised his will multiple times over the years, indicating a thoughtful, deliberate approach to his estate planning, not a sudden, coerced change. This painted a very different picture of Mr. Smith's motivations and the validity of his final wishes. The court had to weigh these conflicting narratives very carefully. The will itself became a central piece of evidence. Mr. Smith's previous wills had indeed named his nieces and nephews as beneficiaries, but the final version, executed just months before his death, clearly and unequivocally named Jenny as the sole heir. The document was properly witnessed, signed, and notarized, meeting all the formal requirements for a valid will in California. Jenny's legal team argued that the burden of proof lay squarely with the family to demonstrate its invalidity, not with Jenny to prove its validity. They contended that simply being surprised or upset by the content of a will is not sufficient legal grounds to overturn it. If the testator followed proper procedures and was of sound mind, their wishes, however unusual, should be respected. This legal principle is crucial. The law generally favors upholding the testator's expressed intent. But the family still had one more powerful card to play regarding the relationship itself. One powerful legal argument the family advanced was the existence of a confidential relationship between Jenny and Mr. Smith. In California, if a beneficiary is in a confidential relationship with the testator, like a caregiver, attorney, or financial advisor, and actively participates in the will's drafting, the law presumes undue influence. This presumption shifts the burden of proof to the beneficiary, meaning Jenny would have to disprove undue influence, rather than the family having to prove it. This is a critical distinction that could dramatically alter the outcome of a case. The family argued that Jenny, as a former caregiver, was indeed in such a position of trust and that her involvement in Mr. Smith's life, even if intermittent, triggered this legal presumption. The court had to determine if their relationship truly met the legal definition of a confidential relationship, which is more than just friendship. But what did the court ultimately decide on this pivotal point? After weeks of testimony, the jury was tasked with a complex decision. They had to consider the credibility of multiple witnesses, the medical evidence, the specifics of Mr. Smith's will, and the legal definition of undue influence and testamentary capacity. The judge provided detailed instructions, outlining the legal standards for each claim. They had to answer questions like, was Mr. Smith vulnerable? Did Jenny have opportunity and motive? Was there active participation? And, crucially, was there a confidential relationship that triggered the presumption of undue influence? The jury's role was not to decide if Mr. Smith's will was fair or if Jenny deserved the money, but strictly whether the will met the legal requirements of validity. The emotional argument from the family about their rightful inheritance had to be set aside in favor of the cold, hard facts of the law. The tension in the courtroom was palpable as the jury went into deliberation, knowing that millions of dollars were at stake. After 2 days of intense deliberation, the jury returned with its verdict. They found that while Jenny and Mr. Smith did have a close relationship, the family failed to provide sufficient evidence to prove undue influence or a lack of testamentary capacity. The jury concluded that Mr. Smith, despite his age and declining health, was of sound mind when he executed his final will and that it genuinely reflected his wishes. They also decided that the relationship, while friendly, did not meet the legal threshold for a confidential relationship that would trigger the presumption of undue influence. This meant the burden of proof remained with the family, a burden they ultimately could not meet. The $3 million inheritance, after all legal fees and taxes, would indeed go to Jenny. This outcome was a massive blow to the family, who had spent hundreds of thousands of dollars on legal fees, only to lose everything. What legal lessons can you take away from this complex case? The most important lesson from this case is the strength of a properly executed will. If a will follows all legal formalities and the testator has testamentary capacity, It is incredibly difficult to overturn, even if the beneficiaries are unexpected. Second, simply feeling that a will is unfair is not a legal ground for challenge. Courts focus on the testator's intent and legal validity, not personal opinions of fairness. Third, claims of undue influence are challenging to prove. It requires concrete evidence of manipulation, not just opportunity or a dramatic change in the will. A common mistake here is assuming that any influence is undue. Advice or suggestions are generally permissible, but coercion is not. Finally, the role of an estate planning attorney cannot be overstated. A good attorney will ensure the will is legally sound and can help document the testator's intentions, making it harder for disgruntled heirs to challenge later. But what happens if you don't have a will at all? Here's what happens if someone dies without a valid will, known as dying intestate. State laws dictate how assets are distributed, and these laws often do not align with what the deceased person would have wanted. For example, in California, if you're single with no children, your parents would inherit. If you're married with children, your spouse and children would split the estate according to specific formulas. Your distant, beloved friend or charity would receive nothing. This process is often lengthy, expensive, and can create significant family disputes, costing thousands in legal fees. For instance, an estate worth $500,000 could easily see $50,000 to $100,000 or more in probate costs and attorney fees if there's no will or if the will is poorly drafted. This means less money for your actual loved ones and more stress for your family. Creating a will is not just for the wealthy. It's a fundamental step to protect your legacy and spare your family unnecessary heartache and financial strain. So, how can you protect your own estate from such legal battles? To protect your estate and ensure your wishes are honored, take these concrete steps. First, draft a clear, comprehensive will with an experienced estate planning attorney. Avoid DIY will kits, as they often contain errors that invalidate crucial clauses. Second, review your will every 3 to 5 years, or after significant life events like marriage, divorce, birth of a child, or a substantial change in assets. Third, clearly document your reasons for any unusual bequests or disinheritances. A letter of intent, kept with your will, can explain your decisions and deter challenges. Fourth, choose your witnesses carefully. They should be disinterested parties who have no financial stake in your will. Finally, consider establishing a revocable living trust, especially for larger estates. Assets held in a trust avoid probate entirely, making the transfer of wealth smoother and less susceptible to public scrutiny and challenge. These measures significantly reduce the risk of a legal battle like the one Jenny faced, ensuring her legacy is secure. But there's another common myth about inheritance that needs debunking. This case vividly illustrates that a clear, legally sound will, even one with surprising beneficiaries, will generally be upheld by U.S. courts. The law prioritizes the testator's true intent over a family's expectations. If you're wondering what happens when a will is completely lost or destroyed and how the courts handle that, watch our video on the surprising legal loopholes in estate documents next. Remember to subscribe for more true U.S. legal cases and courtroom stories told simply, so you can understand the law without all the jargon.